Hello and welcome to Defense Stars. I'm your host, Bob Mata, and this is our continuing coverage of the Commonwealth of Massachusetts versus Karen Reed. Today is May 29th, and I am joined once again by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. And the Commonwealth has just rested its case.
The government is rested. The government is rested. So per usual, my timing with Mark Bederow was impeccable. I got him on a perfect day. We were going to do this Monday, and I was able to get him for today. I had kind of a little bit of a feeling the case in chief might end today. So I got lucky with that. Can't think of a better guest to have on. You know him, you love him. New York power attorney, Mark Bederow. Welcome, my friend.
How are you?
I'm excellent. How are you?
Hey, Mark.
See you guys. How are you?
Good.
All right.
Good.
Still reeling over today.
Yeah.
I saw it late today, but I did see it, so I'm ready to go.
So I'm just going to start. I'm sorry, babe, with the last thing, which really just got me going. I'm going to ignore her whole comment at first and just ask you how in the hell the judge allowed in. My lawyer said if that was the case, I'd have some culpability. How is that relevant? It's insane in my mind.
I don't get it. I mean, obviously the clips are admissions, but there still can be hearsay within an admission that ought to be considered. There's also a prejudicial versus probative value equation that goes on, and to allow evidence that could lead the jury to believe that, well, my
lawyer said she's called.
My lawyer agrees with, the prosecution. That's pathetic. And that should not have come in that form. If you're going to allow that, it should have been cut off before the portion about her indicating what her lawyer agreed with. So but that's par for the course in this case.
Do you remember, and Bob, you too, I don't know. I did not remember, because this was played, I think, pre-trial. I do not remember that end part, because I would have been just screaming my head off then. But maybe I missed it, or maybe they snuck it in. I don't know.
I don't remember it as part of the clip, as part of the evidence that they wanted to play. I think it was part of their piercing attorney-client privilege on what they, wanted to say, which I'm sure we would all agree was a ticky-tack violation, if any violation of attorney-client privilege, as a basis to examine all their communications, which I think is disgraceful as well. But I don't remember them suggesting that we were going to, end our case with this dramatic clip of, she's guilty because David Yannetti says so. I mean, that's just
and
embarrassing.
The funny thing about that is that's a lawyer when he's first consulting with his client, wherein she's throwing some possibilities at him, and like all of us do in that first initial, before we have any discovery, before we know anything about the case, we're kind of just going through the potential pratfalls for that particular client. You know, we're like, oh, well, you know, if they've got this on you, you might be looking at some criminal liability. You know what I mean? You're trying to give your client or potential client kind of the straight dope in terms of what may happen. And that conversation has been taken completely out of context and bastardized in order to try to convict this woman. I mean, look, I hate all of the interviews. It's moved from it was a bad idea to like, I hate the fact that she did them all. And it's not even that I think that they're particularly effective in the way that Brennan's used them. I just, if it turns out that she's convicted and we hear from a juror that it's those clips, it's going to kill me because they're just not evidence, you know?
So I agree with you. Context is everything, obviously. The idea that we don't know what the circumstances of the statement, what led her to say that, what she said before, what was asked of her, what she said after. And, you know, it's not a statement of her lawyer, which in many ways would be more compelling as an adoptive admission as opposed to a straight admission if you heard it from the lawyer's mouth. It's her giving a, regurgitation of what she claims is a conversation, by that point, a couple of years ago, that, my lawyer said, if you hit him, you could have a problem, whatever the hell that means.
Yeah.
The reality is that's the last piece of evidence he offered. And, we all understand how prosecutors work. I was one. Primacy, recency. You want to end big. And that's what he chose, to end big. And if that's your big ending, it's kind of a big dud.
Right.
Yeah. If you're going to play the clips, I guess you offer that clip because, again, it's her claiming her lawyer told her you could have a problem. But if that's your big ending after this guy for 2 days, I mean, this insufferable bastard for 2 days, I mean, I just don't find it compelling. And, you wonder if in a different situation, if a judge hearing a motion for a trial order dismissal might actually consider it.
Yeah.
I don't think she will, obviously, but I mean, I'm still sitting here saying, where's the proof of the vehicle to pedestrian impact? And perhaps even more significantly, where's the proof that to the extent there was any impact, that it was the cause of his death? And I got to tell you, I think the evidence is, I mean, it's hard to say this. It's almost shocking, but in many ways weaker than the first go around, if that makes sense. And
it totally makes sense because I want to kind of get into that pretty heavy duty because in my estimation, well, I'm going to save that. Let's go back. I agree. I think in terms of the way that Brennan decided to try the case, I'm left wanting anything in terms of scientific evidence as to that there was a motor vehicle pedestrian strike. I didn't see it. The thing, the only thing that they think that they proved was that Karen's taillight did not make contact with John O'Keefe's Traverse, and they've put all their eggs in that basket. They didn't give a shit about proving any of the science from 34 Fairview. They've said, okay, here's what we're going to do. We're going to show that the vehicles did not make contact in terms of her taillight being able to be cracked or smashed or what have you, whatever the case may be at One Meadows. And once we prove that, it leaves the jury with, well, if not there, then it must have been here. And we don't even have to prove that over here because if it didn't happen at One Meadows, it had to have happened over here. And to me, it's insane. And I don't think that they proved it at all.
I don't think they did either. But what's kind of surprising is, the One Meadows thing, they at least, Welcher, he used laser optics and other things, which at least are, science, if you accept that. As it relates to the ultimate issue, which is what happened in front of Brian Albert's house at 34 Fairview, there was no science.
None.
I mean, there were these kind of fakakta experiments that were not really impressive. And then beyond that, everything else he did to me wasn't scientific as much as he was like a data analyst, as much as he was presented with a series of facts as the prosecution believed and asked to analyze them. And he said, okay, well, I think this. And it feels like they bootstrapped their theory of the case by putting forth an expert who did not offer a real expert opinion, but had the aura of an expert to kind of, shock and awe and impress the jury with a so-called expert opinion. But I mean, what's the real takeaway from what they did in front of the house? That they were, using paint and doing all kinds of things and talking about, Lexuses blasting off into space as a possibility. I mean, at the end of the day, after 2 days of this guy, I feel like the best case scenario for the prosecution is that the jury says, I don't know. I mean, there's a lot on his direct, a lot on his cross. His demeanor was the worst I've ever seen in my life in an expert witness. And that goes with 26 years of doing this and watching this stuff. I've never seen anything like an expert who it goes out of his way to say, I have no dog in the fight, act like such an asshole. I mean, let's just call it what it is.
Right.
There's no reason for it. I mean, he just acted like a complete dick. Okay. Yeah. And, I don't think that's impressive. And I think also when you see what the defense experts are going to be and how professional they are, that just has such a bad look for the prosecution. And I also think that one of the things they did very effectively through Welcher was establish his confirmation bias, his reliance upon all this, what I would call non-science evidence. And they did a very effective way of really diluting what Brennan will try to do on cross with the ARCA guys, which is say, you didn't see this, you didn't see that. And these guys are going to say, yeah, you're right, I didn't need to, because what I'm governed by are something called the laws of physics. That's science, not, whether two witnesses said Brian Higgins' Jeep was not there and one witness said it was. And then now he's in the role of fact finding about credibility. That is the most unscientific analysis for an expert to do. So, again, really, I don't know if the jury understands it right now. It's going to be up for them in summation to really fully establish. But, right, as lawyers, as we look at it, I don't think it was very impressive at all.
And I think ARCA, they'll be able to use ARCA to kind of bring it home as well. And then again, drive it home in summation. But going back to like what you say, like the takeaway, I mean, my biggest takeaway, I said, all right, crumble up your entire shit and throw it out, because I'm sorry, you don't know that the suspension raises the vehicle 3 inches and then it drops 2 inches when it's turned off altogether. Like, how is it possible? It is your job. You literally went through all of your training and how amazing you are and how smart you are. You didn't think, you don't know enough about vehicles, the science you are testing to check the suspension. I mean, I'll tell you the truth. I wouldn't have known. I wouldn't have thought to check.
So
I didn't think about it.
I think that was devastating, obviously. But to me, the biggest takeaway substantively, and I say substantively because I think the biggest takeaway is the guy's a dick. I really think that is.
He really is.
I mean, I really think that is the number one attitude, is that, or thing that the jury draws, is that you told us you have no dog in the fight. You're just in here to tell what you know scientifically, and you're acting like such a jerk. That's not substance, but I think that jurors are real people. They see that. And I think especially when they see the ARCA people, they will also see that. I mean, in terms of substantively, what do you take away from this guy more than anything else? I don't know. I mean, you said he didn't really know the suspension issues. He certainly relied on a lot of non-scientific data. I mean, you could go on and on with this guy. He just didn't seem to have scientific evidence of what he did. And to me, if you had to pick one issue that the jury's going to say, what's the proof or lack thereof of what he did scientifically? I mean, you're kind of left with like finger painting.
That's what I
Right.
was calling it.
At 2 miles an hour. How the hell does a serious scientist tell the jury with a straight face, in my view, the evidence supports that she pulled up 30 something miles an hour, slammed it in reverse for 80 something feet, right? Not 30
Yep.
miles, 30 feet,
Right.
slams it 80 feet backwards, smashes into this guy. And my proof of his injuries matching that kind of incident are a 2 mile an hour experiment where I'm sitting there in the exact same clothes as John O'Keefe, which, by the way, is freaking creepy.
Freaking weird.
What a whack job. I mean, that is just, there's no need for that. And by the way, he wasn't even wearing the hoodie when he did the experiment.
Right.
So if you're going to play the game, play the game. Like, that's not even a real
Well, Bob said, yeah, then take the full hit and get
Yeah,
scratched.
if you're gonna play the game, take the 23.9, brother, and
So-
let's see that taillight explode. I'm dying to see it.
So he does this at 2 miles an hour. And then and again, this is a job for them in summation, but he also says, I don't know how he got hit. I don't know where he got hit, but let's just assume it was this way. And I'm going to lean into the car and get some paint on me and look at me. I'm covered in paint. I mean, that's a $400,000 expert opinion that they paid for, who had no scientific analysis about the actual incident. I mean, he did more science on Meadows than he did in front of Fairview, which was no science.
None.
Literally. None. Zero. Nada.
Zero.
And Mark, let me ask you, because
Mind.
Bob and I talked about this during our show, and it goes to Emily Morgan's point. So when Alessi tried to bring in Trooper Paul's, the key cycles, all of that, I don't think he needed to even mention Trooper Paul once she had the objection that because he did testify to key cycles, he testified to 1164 being a key cycle, that the defense could have done the same thing they did with Trooper Paul. He started to establish it. The guy basically admitted that if you didn't connect it with the right trip, you could be off. But he could have backed him up to those key cycles and shown 1162 is not the trip from the bar to 34 Fairview.
So this is exactly why nobody or any of the sane people have any confidence in Norfolk County in terms of justice, and fairly or unfairly have no confidence in this judge's ability to be fair and make sure that someone has a fair trial. You have a situation where the current expert has an opinion, whatever, and on direct examination, the prosecutor elicits that his opinion considered, A, B, C, D, and so on, including, Karen's interview clips, very scientific, by the way. The Canton police reports, very scientific. The Massachusetts State Police photographs of taillight all over the ground, very scientific. That's actually a very highly disputed fact, how that got there. But also this Trooper Paul report, which is literally, or some of it is literally contained in his own slideshow.
Right.
And this is like lawyering 101. It turns out that in wanting to impeach this witness, there is credible evidence that amongst the materials he reviewed was a report or opinion of a prior prosecution expert who totally came up with a different view. And to your point, would throw this expert's opinion on its head. I mean, it would destroy it if the key cycles are all screwed up. How is it inappropriate to ask the current expert about other data that the prosecution submitted? You don't have to mention a retrial, whatever, just some other expert before you that says that that's not accurate. And did you accept that, reject it? Did you not consider it? Number one, it goes to the credibility of the current expert just to show what it is in terms of what he considered. And even beyond that, it's a fair attack on his credibility, because one could argue that the prior expert was more correct than you are. And for her to exclude that evidence through this witness is ridiculous. I mean, I can't believe you're sitting here in America and seeing a judge, not a woman's fighting for her life in a murder trial, and the prosecution a year ago was trying to tell you that something happened at 12:45 and the key cycles are all messed up. And it's now been conclusively established that the first expert had the key cycle that you claim was in front of 34 Fairview at a time that the vehicle was in police custody. I mean, that kneecaps the whole prosecution case. And for her to say, I disagree with you, I mean, it's just pathetic.
It's ridiculous. I mean, she's playing hide the ball, which I just don't get. Like we're trying to get to the truth here.
You're trying to get to the truth. And in my view, even more importantly than that, on issues like this, you have to err on the side of the person who has a constitutional right to a fair trial. And that's not the Norfolk DA. That is Karen Reed. And if the DA wants to deal with that on redirect and they can establish it's a bunch of nonsense, they're entitled to do that. But to deprive the defense of even suggesting to the jury that this is a shit show and they're just hunting for experts to say whatever it is on any given day, what they want, and that this guy actually cited portions of that report, the prior report, in his own report, and not bring that up in front of the jury, that's ridiculous. I mean, this is basic due process.
100%. It's basic confrontation clause stuff. And so, like, Joe Flipperhead had a tweet yesterday where, like, this dude actually used the exact document that Trooper Paul had in his report and merely changed the times. I mean, it's identical. Like in terms of, it might be an Excel spreadsheet, I don't know, but the two forms look identical. And really, Alessi's point about the picture of the dash wherein it's showing the mileage is everything, because that's the jump off point for that guy. Like, he had me like, oh, Alessi just nailed it right there immediately. As soon as he made that point, I thought that Bev was going to have no choice but to allow it in.
I mean, the crazy thing is she listens to it. Normally, when she's going to rule in favor of the defense, you know, it has to go under advisement for a day.
Right.
She ruled from the bench within 30 seconds and basically offered no analysis other than, I disagree with you, Mr. Alessi. She's made, in my view, in this case, a lot of really bad decisions. I mean, that it is what it is, and we can agree or disagree about that. But to deprive the defense of suggesting in the presence of the jury that this expert relied on a prior prosecution expert who emphatically disagreed about it, basically the most critical point of his opinion, and not put that out in front of the jury and let them sort it out, let the DA argue all they want, but to pretend it never happened, that's just disgraceful.
I agree. So, and look, I think this begs the question now, do they have to call Trooper Paul?
No.
We don't want, I mean, the guy's the worst witness of all time in terms of trying to extract information out of him, but we have to get the key cycle shit in there. It has to come in.
Yeah, I mean, it's not really going to come out through the ARCA guys based on what I remember from their testimony. They didn't really dive into this for the simple reason they're going on physics, which again, to me, carries the day. None of this matters ultimately. So do I think they have to? No, because I think ultimately science is science, and that's not what Welcher was. Would it be helpful to get out that the prosecution had a disagreement between trial 1 and trial 2 about the key cycles? I think it would. Would I do it? I don't know. It feels. I mean, I think they have a lot of momentum right now. I think they're winning, and I think they're winning by a lot. I think the last, in particular, week and a half or 2 weeks for the prosecution has been a shit show. None of these witnesses have really done what they, wanted to finish strong with. I don't think I would do it. I really don't. I think I'd like that evidence, but I mean, Trooper Paul I don't know if you remember him or how much in detail you remember him.
Yeah.
I remember him
Vividly.
because I was actually in court that day. I saw this with my own eyes in that closet courtroom, and it was bad. It was really, really pathetic. He is clearly not an expert. I don't know. I just feel like you run the risk of bogging it down, losing momentum because it's like going to be pulling teeth. He's not very bright. I don't know if he's even going to remember and get you there. I don't know.
I don't know. I mean, in all of my career, I've never, ever felt sorry for a cop witness.
I don't feel sorry.
I actually, like, at some point I was like, because that guy was just like, they're like, yeah, you're going to go testify about all this shit. He's like, what is he supposed to say? No. He was like, I'm like, I'm outmatched. He's like, I don't really understand it. What happens if the guy starts asking me about what physics are? And like, you know what I mean?
Maybe you should have done the report to begin with then.
Ultimately, I'm not calling him because I don't think Welcher was that impressive. And I just think eye on the ball. You call the ARCA people, you do it, you're gaining momentum. And I don't like the idea of potentially having this kind of sympathetic. I mean, he appears to be so intellectually lacking, if you will, that, I mean, I almost wonder if it just backfires, right? I mean, I don't know.
But
I don't know either, man.
But if you take it more than just showing that the Commonwealth had a different theory, but literally if you're able to show, because maybe they can get through ARCA at least what a key cycle is and how you count back and how would we count back from one, such as every time the car turned on. And then if you're going to have the tow truck driver who's going to say, and I don't know that they will, but I guess somebody that was there for the tow truck, something to say, you turned the car on and drove it. And then they kind of get to the key cycles that way. But assuming through Trooper Paul, they can literally show 1164 was Trooper Paul, 1163 was driving off of the truck into the Sally Port. And 1162 is getting onto a 3-point turn onto the tow truck in the first place. Like you said, I mean, that's literally their entire case. They have said 1162.2 is when this collision happened, but except it didn't. And I see your point that he didn't make that many points in this and that, but to me, it's such a huge point. Unless we're all missing something, because I kind of can't understand how the Commonwealth can't count. Because Trooper Paul said, we rewatched his testimony, I can't explain why it didn't register those key cycles.
My concern is that Trooper Paul can't count. I mean,
right.
I don't know that he will come into court and tell you what day it is. I mean, he was that bad. And I just wonder if it just bogs down into silliness almost, because the first time it felt like silliness. I mean, this is all very regrettable and unfortunate because the judge made a terrible ruling. This should have come out, with Welcher, not that it's 30 minutes of cross-examination, but it was certainly, they were entitled to pursue this. He would have said, I don't agree with it, and that's fine. You have it out there, you have it for summation, and she doesn't do it, and she offers no reason. She just simply says, I disagree with you. And, this is an important issue in a case, and she doesn't even give you a rationale for denying it. And I think that's regrettable. But to me, there's so much that they can do, and they have so much momentum. I just don't like the idea of calling a clown and having it turn into
nightmare.
Yeah, I mean, I don't know if this guy can spell his name. I mean I just
like, that's true. Like, I mean, he appears to be that uninformed. You know what I mean? Like, I had never seen anybody in all my life that was called to the stand as an expert that was just pantsed like that. I mean, I've seen, and we've done it ourselves where you challenge expert witnesses, but I've never seen it where, I mean, Alan was just quizzing him. Like, can you tell me what physics are? Can you define kinetics for me? It was like, because he knew that he didn't know.
It felt like this guy drew the short straw and just was like, sorry, dude, you're the guy.
But the defense would, in this scenario, the defense would be presenting him as a knowledgeable expert because his knowledge has these things being, you know, they can use it to establish what the key cycles are and that the car wasn't in front of 34 Fairview at 11:62.
If he can even repeat it, though, that, I mean, again, suppose on direct, he's like, I don't know. And now you're like, what are you doing? I mean, I guess you can table it until after the other witnesses and reevaluate.
Right.
But my gut is that this guy, you know, was embarrassing at the first trial. She didn't allow it through Welcher, and he probably personally benefits from that. Although you'll have to wait and see. But my suspicion is they're not going to do it.
Yeah, because to Allie's point, I just don't. You can't pawn him off as a knowledgeable witness because that's going to become evident immediately that he's not, in terms of, you know, them trying to extract information. And then, like Mark says, you don't want to lose credibility with the jury where you're trying to pawn this guy off as something that he's not. So, I want to switch gears a little bit. It sounds like Dysart is going to be the first guy that they're going to call. And we had talked about this.
Remind me who Dysart is.
The data guy in terms of the timeline. So he's not an accident reconstruction guy, but I think he would challenge this concept of the time variance. So he's important with the Welcher opinion and the more Burgess than Welcher. And, you know, I had always said, I really think they should start with the ARCA people. And I still believe that.
Me too.
Having said that, this guy makes sense to lead into that. It's not a terrible decision. And I like it, assuming it's followed by the ARCA people, but I don't know if that's the case either.
I kind of wanted to see them bookend ARCA. Like I wanted one ARCA, like either Wolf or Rensselaer first, and then end it with the other one where, because they're like, because we never, like Mark, you know, like you can never know what a jury is thinking, right? Mm-hmm. And if somebody or multiple people on that jury are like, wow, this giant dickhead on the stand was, you know, he because the one thing, Alessi couldn't wrangle him. I mean, the guy is a professional witness. He's a giant douchebag. And, you know, he's like, Alessi got more, you know, like he was trying to wrangle him in and was more direct with him today in terms of shutting him down when he's like, wait, hold on a minute. That shit that he would do, like you just never see. And Bob would, you know, he came at him harder today. But I mean, like guys like that have testified hundreds of times, you're not going to ever get them to change their opinion on the stand. And we as attorneys know that in terms of experts. I mean, the guy is literally a hired gun, right? I mean, that's why it's so critical that somehow it's made clear to the jury that the ARCA guys, as to their first initial report, the most important report, were not hired guns. They were truly independent witnesses. And
I've been
like,
that
drives me nuts.
Yeah, I've been saying this for a week or more. I don't even know. Welcher to me is the quintessential hired gun. This is an expert for sale. Okay. If you pay him his firm enough, the inference is they're going to say what they're going to say, or, you know, and even their fee structure, right? They got a small fee, and then right before trial, they got a huge fee, which I wonder if that will come back in summation the way it was broken up is bizarre to me. But I totally agree. I mean, to me, their whole case is premised on Burgess, who of course has his own issues with his academic fraud, and Welcher at this point. And I think if they call the ARCA guys, you got to nuke them now. I mean, kneecap them, wipe them out, just blow them out of the water based on their credibility, their demeanor, their lack of bias, their science-based opinion, everything. I mean, everything that Welcher lacked, these guys have. And if you do it now, in addition to establishing all of that, I mean, it's the whole primacy.
Fresh in their memory.
Yes, exactly. And I also think that if you call the ARCA people now or right after Disorgia, I mean, that's not sacrificing anything.
No, I agree.
You call them now, you also, I think, beautifully lead into the rest of your case, because after the ARCA guys come off, and assuming they're credible, which, I mean, they will be, you now have established that, well, there's no real explanation for why all this taillight is out there. And that leads beautifully into entering the Proctor Higgins phase of the case, and the weird text messages and weird behavior by the people in the house that the prosecution has no interest in calling any of these people, which is just, in some ways stunning. I mean, not that they should have done it the way they did it the first time, where they called, it felt like 30 people, but right. I mean, they basically called Jennifer McCabe and that's it. And maybe one girl who had nothing to offer, Levinson, whatever her name was, in the house. So I really think that not only are the ARCA people good at just nuking and destroying the whole prosecution case, they lay the roadmap for the rest of the defense case towards reasonable doubt, and it just makes too much sense not to do it that way, to me, anyway.
Do you think that the defense could use, I mean, to Lisa's point, the defense can use Disorga, if he's a data guy, to touch on at all on the key cycles? And isn't it possible, because ARCA did what the defense at ARCA was doing was responding to Aperture's, report. So it is possible that although they didn't touch any of that last time, they may have looked at that and might have an opinion this time. So you think it's possible between those three experts, really, that the defense can get some of this information out?
That's a really good point, and something I wasn't really focused on. That's a really good point, because the first trial, this was a fire drill with ARCA. They had no right to interview them. They had no right to do anything. The feds authorize them to testify. They throw them up there. They ask a few questions about whatnot. The bottom line is, though, that, they're accident reconstruction experts. So it stands to reason that they would have knowledge about Lexus, tech stream, key cycles, and all that crap. And this time, they're not under the restriction of the federal government. They're fair game, and they may very well, and of course, probably have been fully prepped, presented all this information. They've looked at the reports this time of the prosecution experts, which they had not done the first time. So, yeah, I think that's actually a really, really strong point, which is their opinion this time could be well enhanced. And this is probably why Brennan has been having conniptions and virtually a stroke in trying. They're not allowed to say anything other than what they said the first time. So now that I think about it, to your point, Allie, I think that's probably why he's freaking out about it, is because they do know what they're talking about. They do understand this type of data and could at least explain possible discrepancies and whatnot and do it that way. Yeah, that makes sense to me.
And so here's my thing with, I think that the most recent report, that there was such the battle about that coming in, the new stuff from ARCA, I think it's going to be directly contradicting what they said about what happened at One Meadow. Like, I think they've done more work over there. I think that in terms, because I'm telling you, the way that I look at their case at this point, when he skipped all the science about the taillight, there was no, Mark, their case in chief ended with no explanation whatsoever on how that taillight ended up in the front yard. I mean, like, there was no I've never seen a case where, I mean, the Blue Man Group shit aside, like, for like that's one thing, you know, it doesn't explain, you know, kind of the Matrix style thing that must have happened with the taillight where it froze in time in order to cause all these, it explodes, it freezes, and then John's arm moves all over it, and then it proceeds to fly all over the yard. Like, to me, they really decided to take this approach that, look, and I said it early, and I'm going to say it again because I want your opinion on it, because this is the way that the case reads to me. They are hoping that the jury is going to say, okay, if the taillight didn't break when she pulled out of John's garage, it had to have broken when she hit John at 34 Meadows. And that's what their case is.
Well, if that's their focus, then they should all be fired, because
they should all be fired.
The bottom line is this. I agree with you that they put a hell of a lot more effort into the 1 Meadows issue than the 34 Fairview issue, and a lot more science. I mean, the reality is they could have done any number of experiments in front of 34 Fairview. They could have had a crash test dummy plowed into it 20 miles an hour. They could have done a number of things instead of, you know, Welcher cosplaying as John O'Keefe with paint, all that nonsense. But the reality is, as prosecutors, even if you believe, okay, there was no accident at 1 Meadows that could have caused the taillight to crack, so therefore it must be this, and we don't have to prove the rest, they still have the burden of proof. And if you're asking a jury to speculate and assume when you are the party with the burden of proof, you lose. I mean, you can't win as a prosecutor by saying, trust me, bro, if it didn't happen here, let's just assume it all happened here, and, you know, never mind the fact that we haven't tried to establish it before the defense has even offered. And there's all kinds of problems with this. I mean, you could even accept the prosecution argument that the backing up in reverse happened in front of 34 Fairview. I mean, you could hypothetically accept that. That doesn't prove an impact. It doesn't prove a cause of death. It doesn't prove a manner of death. It doesn't prove an accident. It doesn't prove that how the taillight could have shattered. And, you know, this guy's testimony, I think, was, well, you know, once you hit 8 miles an hour, the taillight could shatter. Well, do a freaking experiment at 8 miles an hour.
Right.
Again, I'm not asking you to stick your arm out like a human being, but you did nothing to even establish that the taillight could have shattered. Never mind, well, it didn't happen at the house at Meadows. That's not the issue. The issue is, how the hell did it happen? You have the burden of proof. Show me. Tell me. How did this kill him? They don't have that. They have no medical proof. I mean, the medical examiner said, I don't know. And this doesn't look like traditional auto pedestrian accidents. The neurologist said, you know, I don't know, you fall back on your head, drunk, walking around, it can happen.
Drunk people fall and hit their heads.
And so, to me, I see no way. I mean, again, you can't look at this as a law school exercise. I understand that. And juries are juries, and, you know, all disclaimers apply. But how the hell are they getting proof beyond a reasonable doubt? And by the way, there's been no defense case yet. I mean, we are going fully on. I mean, you could make a credible argument. It's not one that I would accept and follow, but you could make an argument that the defense could get up tomorrow and say, Your Honor, we rest.
Yeah.
Which you see in a lot of cases.
You do.
Don't think I would do that here because they have so much to offer.
Right.
But they could do it, and they can
technically they should win. Right.
And they could win. That's right.
Because one of the points we made, Mark, was let's say the jury believes that he could have been hit by a vehicle.
Mm-hmm.
They have him standing out at the curb. So
They have
he
no
sees
manner-
Karen leaving, right? He runs out in the curb. He's like, hey, what, whatever. He's looking at her peel away, whatever it is. And someone else comes by, and I won't say runs him down because Bob reminds me he has to be clipped, and clips him. And that's how he gets his injuries. Because otherwise, they want the world and the jury to believe that this man stood there very firmly with his arm out, with his glass out, and watched for 80 some feet as a 6,000-pound vehicle came plowing towards him.
It doesn't make any sense. And of course, the defense has no burden of proof, which makes it even worse. And then you add in the other fact, which this witness is ignoring, the Jeep.
The Jeep.
The Jeep.
The Jeep.
The
And
fucking Jeep.
And the Jeep is a whole separate issue because, it relates to other witnesses who are probably lying. But before you even get to the merits of the Jeep, which I think is important and worth discussing, this guy's opinion was, well, there were some witnesses who said there was a Jeep and some who said there wasn't. And he made a factual determination, a credibility determination. As a juror, if you will,
right?
There was no Jeep, which is fine, but that ain't scientific, buddy.
Higgins said his car was there. So
as it stands right now, you have the two witnesses, Nagel and Maxon. The girl was Maxon, who were emphatic that there was no Jeep. Emphatic. And they left and all that. They're not lying. I think everyone would agree that they're just whatever.
Mistaken.
At both trials. No, I think people would say they saw what they saw and they were adamant that there was no other car there. In fact, they were like, we pulled up right behind her. There was no gap. I mean, they left no wiggle room about a Jeep. And in this case, you have Jennifer McCabe who says there was a Jeep. So you add in Welcher, who really his opinion is much stronger from the prosecution standpoint without a Jeep, because she's parked here and goes up 30 feet and then goes back 87 feet. And then he even says that at the end of the so-called triggering event, it's not like the end of the movement, it's just the end of the event. You still are, physics, you're going to move until you slam the brakes and stop. The Jeep would have been there. Now, ironically, could the Jeep have caused the crack in the taillight? I don't know. But if the Jeep is there, then Welcher is severely undermined. If the Jeep is not there, then Jennifer McCabe is a liar. Honestly, I think Welcher's opinion is so weak anyway. The better position for the defense is that McCabe is lying and there was no Jeep, because that doesn't make Welcher's opinion great anyway.
Right. But let me ask you this. Might they just think she's mistaken because they have no reason to comprehend why she would lie about that fact, why that fact would be so important as to lie about it? So for that reason, to me, I'd say I want the Jeep there, because no one believes that if she went 87 feet, she didn't ram into that Jeep, because just like I said, well, they could have been mistaken. The Nagel crew. Do you think that the jury is going to put enough things together to accept that as a lie as opposed to a mistaken belief?
I guess it doesn't matter if Jennifer McCabe either way is not credible, but I'm framing it as she's a liar. And again, I think it's better for the defense case on a macro level. Everyone's obsessed with Welcher today, but if you go back, I think they're better off if she's a liar. She's lied. Remember, you discredit her. Now you're discrediting I hit him. That kind of stuff. You're calling into doubt her Google search and all that stuff. And I think even if you give Welcher the benefit of the doubt that there's no Jeep there, his opinion, at least as it relates to what happened in front of 34 Fairview, is garbage. I mean, there's no science. He proved nothing, really.
Right.
So, but I think they can also play it either or. Is Welcher not credible, or is Jennifer McCabe not credible? And again, if it were up to me, I would call Brian Higgins. Brian Higgins is going to say my Jeep was there. He's already said that under oath.
Right.
He's going to say that. And he's also going to say, if called, that a 6'2" man with brown hair came in the house. Well, guess who was 6'2" with that brown hair? Now, he's not going to say it was him,
Right.
which is, whatever. So they've got problems and inconsistencies all over the place on really important stuff.
So now that the Commonwealth's case in chief is done, all right, and we know what they've laid out, who from inside the house are you calling?
So I'm calling Higgins for sure. I mean, I think I have more of an aggressive view of this than most. I would call Higgins. I would call Brian Albert. I would give serious thought to calling Nicole Albert, and I would give serious thought to calling Matthew McCabe for different reasons. With Nicole Albert, I would be interested in the phone calls from Jennifer McCabe that, Jennifer McCabe says never connected, which is not true. She testified at the first trial about dropping Chloe off at a rest stop or something. And I don't think that's really consistent with what we heard when Buchanan was talking about this. Matthew McCabe, I'm calling about those text messages that are really weird that he's involved in. And I'm also really, really fascinated to hear him, knowing what the jury knows now, to talk about what he claimed was a 3-point turn that occurred in front of 34 Fairview at 12:30 something that didn't happen because, thank you, Mr. Burgess, you've established it happened 10, 15 minutes earlier down the street.
Right.
And that begs the obvious question. Why would Matthew McCabe say that he saw tire tracks in the street that are indicative of a
3-point turn?
Which we know happened. There was a 3-point turn, but I think the evidence that was like whispered into his ear at this point is overwhelming. And then you say, well, okay, well, who did that? And the answer is Michael Proctor, who interviewed Karen Reed earlier that night or that day in Dighton. And Karen Reed said, well, yeah, I did make a 3-point turn.
Which goes back to the point, though, of them wanting to establish that the prosecution presented 2 different theories and 2 different trials. Because without that, you can't get to that point. And I think that point that you just made, subtle as it is, there's really nothing subtle about it. It's an important point.
I don't think there's anything subtle about it. I think the argument I would be making is that Michael Proctor is corrupt and was working on that as the theory of the case. And Matthew McCabe was willing to go along with that. And they're both full of shit.
Right.
And how does that factor into the defense argument that she was framed or that they were doing her dirty? And my answer would be pretty well.
Right. And, to Julie Sriracha's point, the defense can call these people and keep it, like you're saying, Mark, very narrow. And then, on cross, that's what he's stuck with. He's stuck with the narrow topics that the defense raises, and he can't just go, on and ask everything he wants, he being Brennan, off topic.
Yeah. And for somebody like Matthew McCabe on the 3-point turn, he's already testified to it under oath.
Right.
There's no turning back. I mean, what is he going to do? He's not backtracking. So he can say, well, that's what I thought, because those are the tire tracks that I saw. And I saw because there was that like thin layer of snow that tires can make in. So, I mean, he's really dug deep into that. I don't think he can hurt you. This is the same guy who said, oh my God, they're searching, but they're in front of the Asian house. That's a lot of concern for people who are grieving about their friend. I'll drive by and take pictures of what they're doing. And none of this makes any sense with what they're talking about. They have no concern in these messages about John O'Keefe. They're concerned about covering their own rear ends. That's the bottom line. It's obvious that they're trying to stay one step ahead of the constable. I mean, that seems clear. And it doesn't mean that they did anything nefarious in the house. But, in the case of reasonable doubt with all these other issues, and you have already had the ARCA people, and, they've established in their opinion that it's not consistent, these arguments are enhanced, in my view, after the ARCA people testify. And I'm paraphrasing, not literally. There's no accident, no car accident here.
Yeah, and my biggest beef with all the shit that Welcher said was that one little portion where he just threw in there that 8 mile an hour number, wherein that's the speed that the Lexus would have had to have been going in order for the taillight to shatter, without putting it was so kind of buried in the middle of an answer that I don't know if the jury got a hold of it, but it pissed me off immediately, because this is a guy who was the perfect witness for Hank Brennan, because he's just another guy that just says shit, and he doesn't back it up with any kind of science whatsoever. Just literally says shit. I think
that's a great point. I mean, if you have an opinion out of left field that, 8 miles an hour could break a taillight, and I think he called it just a taillight. I need science. Explain to me why it's 8. Tell me the physics involved. And also, he never differentiated between glass, plastic, or polycarbonate. There's a difference. And polycarbonate, as we've now all learned, I didn't know this, it tends to indent inward. It's designed not to explode.
Right.
That's why they make safety goggles out of that material, so that if, God forbid, something happens, it doesn't go in your, it doesn't explode in your eyes, whatever. And he just said, matter-of-factly, 8 miles an hour is what it does. And it just feels like he pulled that out of his ass. And
totally.
No explanation. And I wouldn't be surprised, obviously, if when the ARCA people testify, that there is a lot of discussion about what does it take to get taillight, polycarbonate in particular, to explode, and what might make it happen, what might not make it happen. And if it were to break or shatter or whatever, how would that happen? Because I think the other problem they have is whatever would happen with the taillight, the idea that there would be 40 some odd pieces exploding all over the place from according to Welcher, a hit like this, right? And then he rolls into it like that.
I mean, but because we brought this up before, don't you find it surprising that they find literally every piece of that taillight, except for what would have been missing from the contact at One Meadows? Every piece of that fucking taillight to piece it together. But the glass that's in his hand, they only find like 4 pieces of.
Yeah, no, and I think the inference is obvious. It's not true. And certainly with the burden of proof and reasonable doubt, we don't even have to prove that. But it's a hell of a coincidence. The broken glass on the bumper that doesn't match anything other than what Michael Proctor found on the street, but not John O'Keefe's glass. I thought that was very effective.
There, just perched there.
And it was interesting seeing Welcher just kind of not want to admit that when it was clear he was not familiar with the test results.
Right.
But nevertheless, he still wanted to argue that it didn't matter. It could, but not really. And, what a strange thing for a guy with no dog in the fight to say.
Yeah.
Right.
It's pretty disingenuous. Disingenuous.
I agree.
So I think, and I think I know what your answer is going to be, because I like, as soon as the real, spelled like the real one, Dr. Wolf testified about that I practiced up in Minnesota. You wouldn't believe how many people came in that were drunk and slipped and fallen and had the exact same injury. I mean, to me, that guy immediately became a defense witness. All right, because and I've been throwing this slip and fall shit out there forever. Because I think that people kind of have a misunderstanding that the defense, as we've said, all three of us, thousands of times on repeat constantly, we have no burden ever. We don't have to prove a damn thing at all. And we are not stuck with having to stick with one theory. And to me, if you've got their brain guy coming on saying, as far as I'm concerned, this could have just been John O'Keefe slipping and falling, hitting his head. I don't know how he ends up at the pole. I mean, you've got this kind of treasure trove of these bizarre, nefarious texts and activities of everybody in the house as theory one, as possibility one. And now you've got this gift that if I'm Brennan, I would have been exceptionally pissed off that whole line of questioning came out during his opening or during his examination on cross.
Oh, he asked about it.
Right. And it's like you throw in that as a possibility that maybe this was just a freak accident. Because anything that gets them off guilty is a win.
So the way I would use, I agree, but the way I would use that is, you stick to your theory, your primary theory. You have all these weird text messages, all this. You have the ARCA guys. Obviously, you don't believe it's a car accident. You have Proctor. It certainly fits the profile of a guy who would tamper with evidence. You make an allegation like that, it helps to have a guy who was terminated for being a shithead. I mean, it is what it is. That all that helps.
Right.
I think the way I would use what you just said is to say, look, there's all this evidence that points away from Karen Reed. There's all this reasonable doubt towards Karen Reed. And then you say, what is their evidence that she did it? And it's pretty weak. And then you say, is that any stronger or any different than what Wolf said? That for all you know, a drunk guy walks around, smashes his head on the ground. It could happen. And John O'Keefe, by all accounts, intoxicated. For better or for worse, alcohol was a big part of his life. That's not a criticism. That's just the reality based on everything we've seen for whatever reason. And I think to me, it's a nice side point to say how much reasonable doubt there is. I'm not deviating from my main theory, but I'm using what we just talked about to say that's every bit as plausible as what these people are arguing. But the point is, if we're talking in speculation, supposition, who the hell knows, then this case is over. There's no proof beyond a reasonable doubt based on that, based upon the ME couldn't differentiate between accident and homicide, which is consistent with what this Wolf guy said it could be. How are we here? On top of that, you have X, Y, and Z. So, I mean, I think that was a gift for the defense.
And in the slip and fall theory, you still need Proctor planting the evidence. You're not losing the Proctor evidence because the way I'm arguing that is, look, Proctor had reached his conclusion by early evening that Karen Reed had hit John O'Keefe.
Right.
And it's one of my favorite lines. I use it all the time. It's what one of the lawyers in the Avery case said. And it's true. Cops aren't planting evidence on people that they think are innocent. They plant evidence on people they think are guilty because that's what they know that they need to get the case over the hump. Because if you don't have the taillight, if you're the Commonwealth, we're not here. If that taillight does not exist in this case, we're not here at all.
No, but we're also not here. I mean, if you accept the fact that taillight pieces were found that night, which, again, I'm not saying there's any basis to credit that based on everything we've seen. But if they secure a crime scene properly and there is taillight found that night, I don't think we're here either because I think the case would be over in the other direction.
Right.
But they didn't do it. So, again, to your point, you pile all this on top of each other. And I don't know how you get proof beyond a reasonable doubt. I mean, it's to me, this is not even close.
I know.
And
It's
we're always saying on our channel, I'm like, all right, I know, lots of lawyers and all the legal commentary commenters would take the position that the defense needs to have one theory and not a bunch of theories, but I have never subscribed to that. And in this case, I do think you throw out multiple theories, and in closing you say, look, remember, we have no burden, but we can look at the very same evidence and suggest other plausible explanations. But guess it's up to you to go back there, think about all of this. And if you're back there thinking about other possibilities, whether it's one that the defense put forward or one that you just logically have in your own minds as you're talking about it, that's reasonable doubt.
I agree. And I don't even think it's a different theory, in the sense that, look, our theory is there was no car accident. She didn't do it. Right. Now, if there is evidence that supports that, that's fine. And then if there's evidence, in my view, that corroborates that or explains an alternative theory, such as Dr. Wolf and falling on his head and all that, I don't think that's even arguing inconsistently. Oh, my Siri is going off because I said something. I don't even think that that's inconsistent. I mean, their main theory is there was no car accident, like full stop. However, if you're going to educate the jury and say what could support that is, look, these people are engaged in all kinds of weird communications, weird behavior, that supports that she didn't do it. The fact that Proctor is a freaking dirtbag and may very well have planted evidence, that supports it. The fact that he may very well have fallen on his head by their own evidence supports that she didn't do it. The fact that the medical examiner says, I don't know what the cause of manner of death is between homicide and accident. And on top of that, I don't even see car accident injuries here. That supports it. So I don't even think it's fair to say it's just throwing mud at the wall. I think it all goes together with the primary theory, which is, look, we don't know what happened other than one thing. There ain't proof beyond a reasonable doubt that she did it. And here's why, A, B, C, D.
I mean, I keep thinking about that Ronnie juror guy, man. And that guy shook me to my core in terms of just how the general public really does not understand the concept of reasonable doubt.
I don't know. I mean, that was an interesting interview, and he was very sincere in what he's saying, and I don't dismiss it, other than to say, okay, it's a new round of jury selection and the evidence is what it is, and I'm not losing too much sleep over it. I mean, it is a little jarring to hear, we don't know who hired ARCA, and it may very well have been, Turtle Boy.
Right. And that they discounted, to Tanya's point, they discounted the conspiracy theory so quickly.
I mean, yeah, no.
What was that phrase he kept using? He used a phrase like that it was like
distractors.
A distractor, right? I mean,
look, I don't know if, sometimes you get a perfect storm of whatever. I don't like the way they did jury selection in this case. It scares the hell out of me, one at a time, without a panel, without knowing who's next and your peremptories and all of that. But having said that, I don't think it matters. I mean, it is what it is. You got a jury, you got a different jury this time. We're told, I haven't been there this time. I'm not going there this time like I did last time. I don't think so anyway, depending on how long this goes, because I have to go there for other reasons. But we're told it's a very young jury. That's probably good for the defense, to tell you the truth. I think that's probably a good thing. I think they're probably more, if you believe that lawyers as advocates and being charismatic is a good thing, I think the defense lawyers are more earnest, more charismatic. I think the prosecution's case has been really clunky, just in terms of not just the experts, but some of their other witnesses. As far as the witness we saw the last 2 days, I can't fathom any human being on the planet Earth who says, I like that guy. I mean, right. I mean, and he's a professional expert. That's frightening to me, that a guy, and you also have to remember, on direct, in the very beginning of direct, he tried to be cute and tell little vignettes and self-deprecating stories of, oh, my dad said don't go to medical school, so I did this, and I didn't want to piss off. He's trying to be cute and clever.
Right.
And then by his cross-examination, he's just a dick for the
Giant
sake of being a dick. So, I mean, I'm not overly concerned at what prior jurors, excuse me, different case, different evidence, different lawyers on both sides, actually. Yeah. I mean, to me, I almost believe that it was a weaker case this time than the last time, and that's surprising to me.
I mean, at least in the first case, is fucked up as it was, they at least tried to give an explanation of how the taillight broke. I mean, here they just completely skipped over that fact.
You're right.
I couldn't believe when I saw it. I kept thinking there's got to be some point, and this is one of the things I wanted to ask you. Why do you think Bob didn't get into it with them? Like, he didn't even challenge him on it. Like, if you had to have your crystal ball, like I opined on why I think they did it in terms of Bob. He didn't even touch it. He didn't say, hey, well, it's odd that you didn't really come up with any kind of scientific reasoning as to how that taillight would have ended up in the yard in terms of it exploding. Like, why do you think he didn't touch it?
I think he got out what he wanted to, in the sense of confirmation bias, non-scientific analysis, and they're getting ahead of what, ironically, the DA is going to try to criticize the ARCA people for. You didn't consider this, you didn't consider that. And so I don't think that's going to be effective. I think Bob was laying the breadcrumbs for ARCA, which I agree with. I think he did it the right way. Yep. And I also suspect there's a good chance this time around that, just to dot I's and cross T's and null that attack, that they may very well have said, look, for shits and giggles, we're going to throw you all this other evidence and tell us if that changes your opinion. And they may very well have evidence that we did look at all this and I don't care. It doesn't change the opinion because we're science-driven people, not other things. The other point, this is not science, but we're talking about what the prosecution did and didn't do the first time and the second time. In the first time, by calling 15 or what felt like 100 witnesses in the house, they made perhaps their most effective argument, which was everybody said nobody came in the house. They had all the Alberts, they had all the McCabe's, they had all the kids. Now they don't have that. If the defense calls Higgins, who says somebody came in the house, what is the prosecution's pushback to that? Jen McCabe says no.
Right.
I think
unless they do it all on rebuttal, unless they call everybody on.
No way.
I mean, that's so in terms of Higgins, like, I'm keeping that guy very narrowly tailored. Like, I'm not getting into, because when Alan gave his opening and he laid it out there that, look, there's no evidence whatsoever, and you'll hear it, that there was no arguing going on between John and Karen before John got out of the vehicle, which kind of like in the first trial when the Higgins testimony came on and he was reading all those text messages. And I'm like, and I don't know if we talked about this on our last live together, but like, to me, that gave the perfect rationale of why John might have gotten out of that car hot and gone into that house hot. Like, no matter what the state of their relationship was, we're talking about a Boston cop. We're talking about a guy who's Irish, who likes to get his drink on. And I've got a lot of friends, and I'm part Irish myself. And like, these guys like to fight. Like, they're not afraid to throw hammers. And, you've got this situation where if John goes into that house hot, and he's making a beeline for Higgins. Like, what the fuck, man? Oh, I thought you were my boy, and now I see you're texting my girl. You know what I mean? Like, it gives a perfect buildup as to how that thing would have transpired, and quickly.
To me, and again, people can disagree how aggressive a defense you want to do or not do. To me, calling Higgins is an absolute no-brainer. I'm doing it. And I'm not worried about Brennan cross-examining him by feeding him explanations for his behavior. Okay. Right. You have the text messages. You know what he said. You know that he, got a lawyer and met with the cops after he basically went to the FBI to help him, select what messages to give. He tossed his phone the same time as Brian Albert, the day or two before a preservation order. You know what he was doing in the waterfall with the pointing and the, all that nonsense. The text with Karen. The text with John O'Keefe. What he went to the Canton police. He's doing all these weird things, which is not consistent with his trial testimony. He said somebody came in the house, and now you have the Jeep. To me, it would be stunning not to call him. What the hell is he going to say, even if Brennan is feeding him the answers, that's going to hurt you? I don't think he can. There's no good answers, and you have a full transcript of his prior testimony.
Yep.
You know what he's going to say. He's not going to deviate from that. And so, to me, he's another one of these house money witnesses, but there are so many key facts they could get out of him, which are not really out yet. They're just not there. And I think it would be a huge mistake for the defense not to call him. But, we'll have to see. They obviously know things we don't know. Yeah. But, I mean, to me, that's a no-brainer.
I agree. I mean, he's that guy for all the reasons that you listed. And did you see the new Microdots video from it's all about the Jeep?
No.
They dropped it like 18 hours ago. We showed it to you. And if the Jeep is there, and if you've got the guy that owns the Jeep saying where he parked it exactly, and then we know where he goes because he's on video when he drives. Like, we know this guy's timeline. We know that he leaves the bar. I mean, like, I don't see how you don't call him because of that. Because
something else about Higgins too, which is really interesting. And again, in the first trial, why would he make such an emphasis on this? I don't know. But in the context of the second trial, this is helpful to the defense. Do you remember his testimony, how he made such an emphasis on getting to Brian Albert's house? By the way, when there's no snow, no real snow. And he said, I went in the driveway as a joke with my plow, and I was plowing the driveway, which, by the way, makes no fucking sense.
Right.
There's not even enough snow to.
No, but he went out of his way to tell everyone, I did that. Now, again, I don't know what that means in his mind, and I don't really care. But what it means is this. According to Brian Higgins, who the defense would call a bad witness, somebody who's hiding something, and Jennifer McCabe in the same category, they're adamant that the Jeep is there. And it doesn't help with the Welcher story. It's contradicted by Maxson and Nagel. Why wouldn't you put this in front of the jury and in summation say they're full of shit?
Right.
Okay.
Right. And Ella B points out that Matt McCabe also testified about the Jeep being there. So if we've got other reasons to call him.
But that's also a very interesting point, which is this. Who are the people that are supporting the Jeep? The so-called McAlberts. I don't use that term generally, but, Jennifer and Matthew McCabe, Brian Higgins are the ones that are adamant about the Jeep. Obviously, they're claiming the Jeep was there, and they're perjuring themselves if it's not there. They're not mistaken. There's no confusion. and they put it in a location where Karen would have backed into, if you believe what Welcher said. And it's contradicted not only by Welcher, it's contradicted by the kids who showed up at the same time Karen did. And now you're in a situation where you say, why are the McCabe's and Brian Higgins not telling the truth? Why are they involved in all the sketchy text messages, butt dials, phone calls, and all that stuff? And here we go with reasonable doubt. And that I don't know what these people did, but the argument is they're not acting like innocent people who did nothing wrong and just had the sheer misfortune of being in a house when their good friend ended up dead on the lawn. They're acting like guilty people of something.
Right. What it is, who knows? But
who cares?
Yeah, right. Yeah. Who cares? That's not the defense's problem. Like, because I keep trying to tell people, I'm like, and I understand the need and the want and the desire for real justice for John O'Keefe. If you're of the mindset that whatever
that's never going
to happen in that house, it ain't happening in this trial. This trial, only one person can be found guilty in this case, and that's Karen Reed. So she's got to be the focal point, because the way that I feel about it, I'm not putting the gas to the floor on the whole they went into the house. I'm doing exactly what you said, and I'm gonna put it in. I'm gonna pepper the jury with the facts, all the disturbing little things that really don't indicate people that didn't have something to hide. There's just too many of them. There's just it's too much for you to ignore. But I'm
also turning it and using Jennifer McCabe's words against her about, how upset we were and how awful. That's what she says now. That's not how they acted then. Look at the text messages. You look at everything they did. It doesn't suggest that they gave a shit about that guy, which is what his name was, by the way, not John O'Keefe. That guy. Tell him he didn't go in the house. They're looking here. They're doing this. Everything in that text message chain, that the inner sanctum of the family, the close-knit people we're talking about, was about how to stay one step ahead of the cops. What do they know? And more importantly, what do we know? Kerry's telling them everything. Like, don't talk. Well, I don't want to text. We'll do this. Tell you tomorrow. That's got nothing to do with John O'Keefe. That's got to do with them. Okay. Right. I mean, those are things that I think they need to get out there. I think when they call their cell phone expert, for example, they need to get into Jen McCabe's Google history. And I'm not talking just about how long to die in the cold. I want to know why she was Googling herself within 48 hours of this incident. She's so concerned about John O'Keefe that she wants to know, oh my God, is my name going to be in the paper?
Right. And, you put all this stuff in and the stuff about Higgins. And then to Tony's point, jurors on their own will be like, well, maybe Higgins punched that guy in the garage and the dog jumped up and he fell in the garage. Like even they can come to their own conclusions back there when they just hear, oh, he deleted a bunch of stuff. His car was there. His car wasn't there. What is it about Higgins? There's something about him. And they can be back there and decide on their own, similar like what Tony decided.
There's so much about her, McCabe and Higgins. And if nothing else, Higgins is going to say some guy came in the house. And then when pressed on it, he's going to say, I don't know who it was, but it wasn't, it wasn't John O'Keefe. He'll say it wasn't John O'Keefe. But who the hell could it be?
Right.
And again, no burden of proof here. Everyone, Jen McCabe says nobody came in the house. Higgins says some guy matching John's description did. So who is it? If it's not him, and why didn't Jen McCabe see him? You could even argue she's not even lying, which she probably was, but maybe she didn't see him because maybe they were in a different part of the house. Maybe they were in the garage and not the main area. I don't know. And frankly, it doesn't matter because there's no burden of proof. But these things that Higgins is saying and McCabe is saying, and with the Jeep and all this other stuff, it's an incredible opportunity. I think the prosecution has given the defense, and there's no reason to be deterred by, oh, well, Brennan gets to cross-examine and spoon feed them answers. What's he going to spoon feed?
You know, KRP makes a great point. Higgins is saying he had to plow snow because, remember, wasn't it Higgins that said his body was behind a snowdrift, or somebody said his body was behind a snowdrift? So makes a big deal about plowing because they got to get him behind a snowdrift.
I don't even know, other than the fact that, you know, Higgins was the first one to show up, is my recollection. And if Higgins was the first one to show up at the house, which is 5 or 10 minutes after they left the waterfall, you've seen the video outside the waterfall. There's no snow.
Right.
Dusting, not even. I mean, it's starting.
Well, as Sarah said, and as the expert said, enough to track a cat. I mean, that's about it. Not a pile of snow.
To track a cat. I'd never heard that one. That was a new one.
I know. I hadn't either, but I kind of loved it because it really, it gives you a very vivid idea of just exactly how much snow there is, because if it's too much, you're not going to see the cat's tracks. So it gave me a very clear, I can see that being some shit that weather people say all the time. All right. Like, in terms of, and I'm always worried about jurors, man. I just am. I've been doing this long enough. I'm always worried about jurors. If you were doing the summation in this thing, I mean, how much time are you spending on pounding them over the head with the concept of reasonable doubt?
To the point of making them want to pluck their eyeballs out and stab themselves in the neck.
Right.
This is not an exercise in oratory skills. Obviously, that's preferable, but you're in a situation where you're on a strict timeline. There's a lot to do. There's a lot of moving parts. And to me, the summation has to be starting with ARCA, which to me is the quintessential reasonable doubt, and tell the jury, stop right there. That's it. We're done here. Reasonable doubt. And then I think each fact you add, I would point out more reasonable doubt on top of this. And it may be boring, but you're fighting for a woman's life here. You got to do it. And I would pound it endlessly, incessantly, drive everyone crazy. I've done this before in certain cases. You have to, because the first time they did it, they didn't do that. And it was more like giving the jury an ultimatum of, she did it, or, you know, one of these 3 third-party culprits did it in the house. And you can't do that. You have to just repeat each fact as reasonable doubt and reasonable doubt and reasonable doubt. And the advantage that they're going to have is, even if it sounds boring, which it doesn't have to, the good news is they have like the ultimate orator giving the summation. So it makes it less boring. Because you can modulate and, you know, use pregnant pauses, a lot of charisma, and do it in a way that's not like the idea of like Brennan droning on for an hour with that tone and not modulating. So, you know, you have a huge advantage. You have somebody, you know, in Alan, who's going to give the summation, who's like just an incredible public speaker and has a lot of charisma in connecting with a jury. And I think if you take his connection skills and oratory skills with the right substance, it's compelling.
Yeah, no, I agree. And it's like I miss Yannetti. I'm not going to lie, because he's such an everyman lawyer. I think he's just got that.
Very good lawyer. No, they're all like really good.
They're all great lawyers, and they all bring a different vibe. You know, you've got the educator in Bob, and then you've got Alan, who's just got that charisma, and then you've got like Dave, who's just like the everyman lawyer. Like he's that guy that, you know, I'd be like, oh, that's the dude I'm going to go have a drink with. Like after the case, and you're going to sit and shoot the shit with that guy for hours, talk sports, you know, do all that. And you don't necessarily get that vibe off of Alan. Alan's like, oh, we're gonna go eat some sushi, and then, you know, he's gonna fly.
That's actually not true. No, he's a fun guy to have a drink with.
I'm sure he is. I'm sure they're all fun guys.
I get you though. I mean, look, obviously he's gonna do the summation. There's no question.
100%. Yeah, there's no doubt
And
about
there's all the witnesses that have to get presented by the defense still. So hopefully we'll see lots and lots of Yannetti.
Yeah, I mean, I kind of get the impression that Alan's probably going to handle the House people, you know? Like I keep trying to figure out where David's fitting in terms of like where they kind of earmarked him, because obviously Bob's going to handle all the science guys, you know, and I'm sure he'll do a beautiful job with it. When you kind of sit back and think about the amount of information that Alessi has had to digest.
Oh my God,
dude, it's unbelievable in terms of just how, and to like know it like the back of his hand. I mean, you know how it is. I mean, when you're litigating, you have to know the facts of your case forward and backwards. And it's that thing where, you know, when it comes to expert witnesses, you know, like I'm no expert in physics. I think I saw in the chat, I already screwed up kinematics. So, you know, that's not my, like, I'm a lawyer, man. I'm not a math or science guy. I rely on experts to teach me.
Well, that's the advantage that Bob has, is that I agree with you. Whenever you deal with an expert, we've all done it. The advantage that they normally have over you, you know, you can try to do it your way. It's your forum, the courtroom, you're better and all that. But their safety blanket, if you will, is they can talk over your head. And at some point, if you can't keep up substantively, there's very little you can do. The difference with somebody like Bob is that he's a science nerd. And he actually, I'm not going to say he's literally at the level of these people, but he kind of is. And so if they want to get all technical and go toe to toe on this kind of stuff, he's right there. Right. So they lose that advantage. That, I mean, like a guy like Welcher, you can picture, is used to being the way he is, you know, and he gets lawyers in any case he deals with, and he talks over them. And let's be honest, most lawyers are going to be like, I don't know what I'm talking about. They back down. And you could see it with Welcher from the jump about what an arrogant jackass he really was. The first comment he was, I didn't catch your name. Like, what's your name?
Right. I want to be nice. We haven't met before.
That was designed to stun him and just get him off kilter. And, you know, obviously it didn't work, but, you know, maybe yesterday he was a little bit too nice, maybe. Not today.
Not today.
Today was like, I'm done with this. And that was good.
Yeah.
Not that he was bad yesterday. He wasn't.
He even came in hot with the take off his Apple Watch even.
Love that.
Tina says. And what do you take with this bag of tricks? And, you know, like, to making it count said, and like Dina said, you know, with the Apple Watch and the, you know, the laptop.
It's ridiculous. I mean, the only thing I would have liked to have seen yesterday when this was happening was, and again, maybe I'm just more obnoxious and like to poke a little more, but like, what are you looking at? Why are you doing this? And can you tell the jury what it is you're looking at, and why are you writing notes? He was writing notes.
I kept saying the same. Stop writing notes.
Say, can I see that, please? Because I think that's appropriate, actually. And, you know, whatever. I'm not a nice person in that regard, but I mean, what he was doing with his laptop and his notes and whatever else, it was ridiculous. And this is a professional expert too. He knows the rules of the game. He knows you don't do this.
I think he must do it all the time. It seems like he couldn't be up there without doing it.
I assume he has a shtick that he uses, including saying, I didn't catch your name and this, and I'm going to throw you off guard. And, you know, every time the lawyer says, thank you, you're welcome. I mean, it's just, there's just a lot of weirdness with this guy. But obviously Bob was the perfect lawyer. I mean, we're talking about what lawyers doing what, perfect for this, because I mean, look, you guys have been doing this a long time. We've dealt with experts. You've seen lawyers doing experts. As far as it comes to like wonky subject matter expert type stuff. I've never seen anyone dig in on an intellectual level like he does. And it's interesting too, because, again, when you're doing trials, if you were saying, all right, here's how we're going to break this up, who wants to do all the experts? You'd all be like, I want Jennifer McCabe, Proctor. I want to
right.
I want the full
my sleeve. I want to fight.
Right.
And he showed up as the perfect lawyer at the perfect time in the perfect situation to do it. And he's done it expertly. So,
Kiwi Green points out, and this, she's not the first one to do it, but she answers your questions about the 8 miles per hour that in this Kiwi versus Simmons was a civil case, and Welcher was disqualified for unscientific methodology that he asserted with an engineering degree of certainty. And someone else told us that in another live. I was really hoping that assuming that's accurate, she's the second one that does it, and she says it's a 2022 Massachusetts case. The defense missed an opportunity maybe to show that he's been disqualified before.
If it's a Massachusetts case that he got disqualified on similar methodology, that does feel like a missed opportunity. I don't think it's going to matter in the grand scheme.
Me neither.
I don't think Welcher, even if Welcher was never cross-examined, I don't think he was impressive.
Right, and 2 people mentioned that
Maybe
hat. I missed it.
Rebuttal. It's possible.
That's true.
Yeah,
Maybe it between now and then.
And the way we do this, he's just going to show up and rebut. I did see the thing you mentioned, his hat. He asked the judge, could he pull out his hat? And I don't know, is he going to put it on and put on the T-shirt and put on the sneakers?
It's bizarre.
And I didn't get it because they already had an expert talk about.
You're too nice when you say bizarre. That was sleazy, I thought.
It was totally sleazy. It was weird.
But it made no sense. They had an expert that already got on the stand, a brain surgeon, for God's sake, and explained that injury. He didn't mention anything about any other scrapes or something that was inconsistent with having been just from a fall. Now, all of a sudden, you want to put your hat on and show. I missed it. Bob told me about it, but
he said it. I remember the hat. And he said a lot of things that were weird. He even said when he was getting challenged on, you could have done an experiment at 20 miles an hour with a crash test dummy. And, I think he said something like, well, you can only try that 1 or 2 times. The car would get damaged. And if it didn't work out right, then you would criticize me for this. And it's like, yeah, that's the fucking point, guy.
Exactly.
If it doesn't show it to work, that's the point. Maybe it's not sound science. If you wanted to know how result oriented and how biased he was, it was kind of that 20 or 30 seconds when he said, well, if I did it that way and it didn't work out, you would criticize me.
I know. I was screaming my face off. Exactly. And that's why you didn't do it, because it wouldn't work. And it goes to Sandy Beats' point. And Bob, you've been screaming about this yourself, that he could have used, all right, let's take what he said. Well, we don't want to damage the vehicle. Do all your scans, do all your thingies that you've done, do everything that you just did. And then, you know what, as San said, back up John, back their vehicles into each other. And then we don't need all these, you can prove it. You can do it. You can show it.
The worst thing that would happen is you reduce the blue book value of the Lexus. But what's the difference? Because Morrissey's on the hook for paying for that too. So who cares?
Right. Especially if it helps prove your case.
Right.
That silence is deafening to me. The fact that they didn't do that. Because I'm a juror, I'm asking myself that exact question. Then why didn't they just back the damn? They bought the damn car to not back it into the other car. Is that what you're telling me? That
there it was.
Look, if I'm in summation, I'm getting up there and saying, we need to just break this down to its core. Okay. They took their expert, and, I'll leave it to you, ladies and gentlemen, to assess his demeanor and appropriate, whatever. He put on an outfit to emulate John O'Keefe, put paint on a taillight, okay, and had another employee back up a Lexus that they bought, not her car, same model, whatever, at 2 miles an hour, which is 22 miles an hour less than he claimed, and quote unquote, it hit him. And they're claiming that that is, compelling proof of the injuries.
Yet we still don't know, to Stacy's point, we still don't know the point of contact.
Which they admitted.
Right.
Which they admitted. And that is their so-called science. They pay, and I would say
suspension.
With the wrong
suspension.
And what I would say is this: they paid their expert, they paid the taxpayers $400,000 for that. Now juxtapose that against ARCA. We didn't pay a dime. They didn't even know who we were. Right. They're real scientists. And they did these experiments, and without even knowing who our client was or caring one way or the other, okay, concluded this. How do you lose when you draw that dichotomy between level of expert, bias, integrity,
why
silliness?
He's holding a glass in his hand? To your point of him like basing it on people's statements, and Carolyn's point, why is he even holding a glass in his hand for your reenactment? And how do you know where to hold it and where to stand? And that's what everyone's saying. We don't even know the point of contact.
I think the answer is he wanted to garner sympathy, that people would say, "Oh, that's how he looked." And I think it's really sleazy. Yeah. There's no other explanation for it. I mean, look, if there was an issue about, a different type of T-shirt could cover whatever. The other thing I would say in the summation is this: the bottom line is, in that experiment, he took off the freaking hoodie. So at that point, there's no clothes experiment. Okay, you blew it because he was wearing a hoodie, and maybe you should have, had the hoodie on and see where the paint goes. I don't know, but the point is, we're making all these differentiations and things that aren't science. They paid $400,000 so far. I mean, he really should have asked, what more do you expect? But whatever. No, I'm serious. Are you getting paid for your time to testify and all that?
Of course he is.
But they paid all that money to have a guy play with paint.
Kindergarten hand painting.
Stupid.
He's moving his feet, he's walking. And like Bob kept saying, if he was really standing and where he was standing for his little finger painting experiment, he would have been plowed down at 24 miles per hour.
So the other thing I thought was interesting about his, experiment, if that's what we're calling it, if you watch the video of it again, and I didn't think of this the first time I watched it. Somebody put it on Twitter. I think it was our good friend Joe Flipperhead again, actually. Joe, hope you're watching. When he did that impact, and by the way, at 2 miles an hour, right? The car hit him, and according to Welcher, he went forward in the opposite direction of the car. The DA's theory is that he got launched backward. Okay, but watch the video. You'll see him hit the car and fall forward. In other words, they're just making this shit up as they go along. This is not science. They have no clue what they're doing.
They have no
I know.
idea.
Amber says she's been 20 years an engineer. It's physically impossible for him to project several feet from an arm impact with those injuries. The concept's so basic, there's no fucking way Welcher believes it. To your point.
And, I don't think this came out on Cross today, but, the other day he said that, head injuries are the most common injury from a car strike. And he cited like some 1978 article or something. I mean, this is why the internet's a fascinating thing. Somebody put up a video of him doing one of his where they did like a crash test car. And he was talking about how the most common injury are legs. And this is much more recent. And he didn't get crossed on this today. It would have been interesting. So the jury doesn't know this, but the intellectual dishonesty from this guy is just off the charts.
Off the charts. And it's a shame because I think they'll hopefully they're going to get it, when ARCA testifies. I mean, but and
I don't mean to interrupt you, but the thing about ARCA is this too. why they're going to be probably so much better than the first time, notwithstanding Brennan's theory that, you know, the night before they testified that, you know, Dr. Wolf and Allen were playing footsie on the phone for 9 hours, plotting this all out. They did, you know, it was kind of a fire drill the first time. They just were there. They didn't really get to interview them, and they just kind of threw them up there and had to work off their report. This time, their defense witnesses fully prepped, fully briefed, have seen all the other stuff, have had a chance to, like you said earlier, expand their reports. And you have to think, as compelling as they were earlier, it's going to be that much more impressive this time. And it kind of makes sense to you as to now, in hindsight, when you saw Brennan in the pretrial stuff, and actually during the trial as well, basically whine and whine and whine that if ARCA is allowed to testify at all, you know, only their original report, nothing new. They're not allowed, which is ridiculous. Of course.
Well, and a lot of people are asking that in the super chats. Why is Aperture allowed to update their, you know, reports and update everything and get new clips when I can't imagine that she's going to allow them to give their first witness, Trooper Paul's report, so he can talk all of a sudden about something he didn't have or give
Listen, I was a strong proponent of a mistrial when all this nonsense started with the moving the goalposts on this mid-trial. I mean, I've never seen anything like this where mid-trial they do this. And, you know, they went out of their way with Burgess to establish that the DA had nothing to do with it. It wasn't impressive. It wasn't believable. I don't know if the jury gets it or not. We're lawyers. We understand that. But when you saw the voir dire of Welcher, they're not even hiding it anymore. I mean, he's like, yeah, Brennan told me, just, you know, and then they turn over an updated report at 3 p.m. on Memorial Day when the man is testifying the next morning. Okay. If you don't need any proof if there's one piece of evidence that you need to know that the prosecution is just full of scumbaggery, that's it. I mean, the idea that mid-trial, while they're whining and whining about all the disclosure they're entitled to from the defense that they don't get, and they have the gall on Memorial Day, assuming these people are, you know, working or at a barbecue or traveling back from California, whatever they're doing, right before the guy testifies to say, here's our new report. Embarrassing. I mean, that's just
so. The answer to everyone's question is no. The defense is not going to do that because you're not supposed to change a report mid-trial. But she did. Do we know whether the defense experts? I thought they were excluded from the sequestration order as to watching the experts they're going to be essentially rebutting testify.
I don't even know. I mean, she's all over the place with like sequestration orders. But I mean, you know, there was a lot of cross-examination at the pretrial hearing about it. And, you know, then there were some people who were saying whether these witnesses were excluded. But then when they were complaining about the Aperture stuff, the judge said, oh, you can cross-examine about whether he violated the sequestration order. So you're like, oh, it is in effect. In this court, who the hell knows? I mean, honestly, I don't even know at this point.
I know.
Good, babe. So
if you had to make a prediction, how long do you think the defense's case in chief is going to last?
I don't know, because I mean, look, again, we can all agree, and it's an interesting philosophical legal exercise. I would have a big case. I mean, I would call the ARCA guys. I would call Dysart. I would call Proctor. I'd call Higgins. I'd call Brian Albert. I'd call Dr. Russell, the other dog person. I think I would probably call Matt McCabe. I would strongly consider Nicole Albert. I don't know if they're doing that. We know they subpoenaed, but put on their witness list Michael Proctor's friends who got the text messages. The only interpretation you can take from that is they're not calling Proctor. I mean, I don't know how else you could interpret that. There's no reason to call these friends if you're going to call Proctor.
Well, yeah, it's one or the other.
I think
I
I'm
don't,
calling Proctor.
I don't understand it, but we're also not privy to what they are.
Right.
But
Right. And they've got 5 brains powwowing with all the information that they have to decide what is the downside. And I think you mentioned it before, there's always that risk when it's retrial that they're going to clean stuff up. They're going to figure out where they were short. Now he's going to come up with an explanation that he didn't have the first time,
I don't see, to me, someone like Proctor is, buddy,
Can't get worse.
for cross-examination. I'll tell you what, I'll sit down and you can just say whatever you want and I'll just listen to it. There's nothing that guy can say that's going to harm me. I mean, what is he going to say? I didn't plan evidence. I didn't, jam her up. I was honorable. Yeah. I mean, what can he possibly say? Also, if you don't call him, you're also leaving the whole Sally Port video out. Remember, they kind of threw it on him.
Right.
That he held it. You're leaving out the potential bribery because those friends can't speak to those text messages about the bribery. I think you're leaving out the tunnel vision argument. I mean, really putting it on the jury that he never went to the crime scene, but he spoke to Jennifer McCabe. And before he ever got down to Dighton, he was deciding, I'm towing the car. I never took a picture of it. I never did. I mean, to me, look, these people obviously know what they're doing. These are like top level people, and having spoken to them, they know exactly what they're doing, clearly. But it's kind of a strange thing to me not to call him.
Yeah. I think me too. Like, like you said, though, I mean, they know their shit. They know how they want this case to line up. I mean, I agree. I mean, there's no way in hell that I'm not calling them, but maybe they've got other ideas, but yeah, there's just so much there that they could just lay on that guy. And it's that one question that you're posing to the jury in summation. Why did we have to call the lead investigator?
That's the thing. I think if they put a face to this name and say, in order to get the truth, ladies and gentlemen, took us, not them, us. They have the burden of proof, and they want you to pretend this man didn't exist. Why
that could be why they're not going to call him. They'll put on all these other people, and then they'll say, now you know why they didn't call the lead investigator. Yeah, and that might be playing into it.
Yeah, they still have that argument. I just like the optics of hauling him up there and making him read these texts and all these other things, and just let him, again, he can fight, he can argue, he can roll over. I don't think it matters. I mean,
because you can't do that thing that Alan Jackson did with Proctor, throwing the C word out there over and over again, making him read it out. Like the judge had to turn to him and say, you got to read the words. I mean, we're not going to get that again because he knows that's going to be the answer, but you can't really, it's like making the friend read it outright. That's just icky,
I also think that, I mean, if you call him, I mean, to the extent, I don't know that they're overly worried about like the Welcher stuff or whatever, but when you call somebody like Proctor, the jury is going to be like laser focused. I mean, that is the kind of thing where they're all going to be leaning up in their chair, just leaning into this and listening to it. And to me, he is such a perfect witness to call right after the ARCA guys, because once you've established that there is a strong argument of no car accident, the taillight issue becomes a hell of a lot more plausible and believable. And here comes the lead scumbag. And he's the guy who takes the heat for the taillight. And it just becomes so much more believable after the scientists are saying, yeah, I know there's 47 pieces of taillight on the ground, but the science says no.
Right.
Taillight
case right there.
Some other way, perhaps.
And I don't remember if I asked you this before, to selective memory failures point. Have you heard the fact that the Traverse, that John O'Keefe's Traverse had been repaired?
I mean, I've heard that. There's no evidence of it in court. I have heard the internet stuff. But one of the things that was really interesting a couple of weeks ago, which of course feels like 8 months ago, didn't Jennifer McCabe said when they were
Yep.
making their appearances and sympathy calls that, you know, the car repair guy was there. What a weird thing to say.
Yeah. Yeah.
I don't know
That's
what
when
it
that's when it came up when she said that everyone was saying, "Oh, remember how they said that his Traverse was repaired."
I've
Mm,
heard that, you know, on some of the, you know, online stuff, but I've never seen evidence of it, but who knows?
right.
All right. So, final thought. Do you have a final thought? Like, number one, I appreciate. Are you fighting a little throat thing there?
Yeah. God, it's like
Yeah.
2 weeks of this. Yeah.
I know.
Is it that obvious?
No, it's not. But I
It's
can
not.
tell. Like, I
Yeah.
get those little throat things too. Man, we love you over here. We appreciate you giving all your time. I saw your epic 4-hour thing with Ian. You know,
And
it's
talk.
yeah. As much
so
as I'd
fun.
love to keep you for 4 hours, man, I'm just not going to do it because
Well,
I really appreciate your time, and I love to hear your thoughts, and I hope you'll come back during the case in chief.
And don't worry, people, I'm going to still go over the supers that we haven't yet, but I've been incorporating them in.
Like what at some point, what we should all do is I picture Ian lives in like the middle of nowhere, Western Canada. That's just I don't know, but I don't picture him in like Toronto. I picture him like way out in like Saskatchewan somewhere. And what we should all do at some point when this is over, go out there, a lot of whiskey, sit in his log cabin and just listen to his stories because no, he's like a great guy to just talk.
He
And
does. He's
talk.
got good stories. He was telling me about one of his trials and giving me like the whole background. We were at CrimeCon, I think, or something. And, you know, a lot of people want to talk to him. So like, I don't know, 3/4 of the way through, I let him go because people were talking to him. And then I reached out to him after. I was like, you know, one day you're going to have to tell me the rest of that story. He's like, oh, which one was it? And I was like, I tried to throw out a couple of facts about it, but yeah.
Fun. Yeah, a lot of fun.
All right, Mark, we love you, man. Take care of yourself. Hopefully I'm going to try to get you next week. I'll see what your schedule's like, but man, you're the best. And, let's get Karen off this thing, man. Let's go.
It'll be over soon. A couple weeks, right? It'll be over.
All right, brother. Thank you so much, Mark.
Hey, guys.
All right, bye. All right. And I got a dip. I'm going to. All right. I love you. I love you guys.
People are going to talk.
Make sure you like, share, and subscribe. I'll see you.
Yep. So I've been trying to incorporate a lot of your guys' super questions. And yes, Mark did allow Bob, and he discussed it before. He was okay with super. So I tried to build a lot of them in. I tried to highlight them when the topics came up. I read some of yours outright. But, you know, let's talk about also, and Mandy, if you're here with me, stick up ones of people who members or, you know, comments of people that still feel they've got certain questions unanswered. What else do you guys all want to talk about? But, you know, we brought this up that they can, you know, call. Julie Sriracha asked it, and there was someone else who asked about them limiting it to what's on direct, and I'm going to try to find it. And then someone else asked about why they'd be able to get into a certain issue if they're limited on direct. And I want to explain that, limited to what was done on direct. And I want to explain that to you because there's a certain part. Yes, for the most part, the cross-examination is limited to the topics that were raised on direct. However, the confrontation clause always allows you to bring up bias. Oh, I remember what it was. Someone's comment was like, well, why is Brennan going to be allowed? And man, if you can find this comment, stick it up there. But why is Brennan going to be allowed to bring up the fact that ARCA was using Signal if the defense doesn't bring it up on their direct? And that's because that's considered bias or goes to credibility, things like that. So things like that can always get raised just pursuant to the confrontation clause. So in a sense, yes, they're limited substantively to the issues that are raised on direct, but you can always bring up anything that shows the witness's bias or leads him to be not credible. Although the judges don't always make the best rulings on that. But yeah. So thanks, Sriracha. Thanks, Kelly. She watches every day. She's so much to say, but she's usually working. So I'm glad she got a chance to do that today. And I agree, Emily, at this point, the defense should make every witness review Trooper Paul's report and keep talking about 1164 key cycles. We did kind of circle into this during the discussion because they're not supposed to be changing, everything mid-trial. So they're not supposed to be having witnesses, review stuff mid-trial and then change, adjust their testimony or testify on it. But they can talk about things that came out during the direct of an expert who who is questioning that. So those issues could come up on cross. You just have to kind of see. Hi to all our new members and old members, Jen, and gifted memberships. Thank you. Lady says, excited for tonight's discussion. I see it the other way. So now she's talking about that first clip that we started with tonight. We were saying how it seemed it was ridiculously prejudicial that the judge allowed the Commonwealth to use a clip where at the end, the lawyer is saying, well, then you might have some culpability. But Lady Die 2 saw it the other way. She saw it as that seems like an honest lawyer stating a fact and then realizing, wait, she didn't do this. So she was thinking that the jurors might think the same thing. Allie, pull this live over and ask everyone to hit the like button. All right. Well, everybody hit the like button. Please hit the like button, especially if you're leaving. Just minimize that chat and hit the like button. All right. So Nandy's telling me I went through most of your chats. I don't want anyone to feel like I didn't. We tried to incorporate the super chats into the conversation as they were going. Last one, because he just sent it. MJ and IA33. Bro is retired auto tech instructor who says impact with arm would break before polycarbonate taillight would break. Very highly improbable it would shatter. So yeah, and there's a lot of you commented about this, and we talked about it the other day. Polycarbonate is designed not to shatter into dangerous shards that could hurt somebody. It's designed to do that. So no, and I know Be in Trouble 31. He did a demonstration showing how the arm would break before the taillight would break. So that's all that stuff. And Zoe points out that Welcher had the drink in his right hand, but she says that John O'Keefe was using his left hand to drink and his right hand to text. So, yeah, how did he know how to drink? All right, Mandy tells me the live is over, so the live is over. Please, hit the like button on your way out. Thank you, everybody. We appreciate all of your, all of you being here, and we will see you tomorrow. And we've got know if it's just you because.
Allison. Hey,
All right. Thanks, Mandy. Thanks, everybody. Bye.